Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me, my good friend and special guest, Russ Cook with Russ Cook and Associates over in Brentwood, Tennessee. Russ, again, is a board-certified estate planning attorney. He's been doing this for over 30 years, I think now, right? Wow.
It's a long time.
And he's got a whole family. I always tease Russ about how the holidays must be around the dinner table, or, you know, with dad and granddad and all this kind of thing.
Yeah.
This generation after generation of estate planners.
Very, very boring for those around us, but we are energized by it.
That's right. I can imagine, right? How exciting. Okay, pass the turkey leg, and let's talk about what happens if.
Yeah.
One of the things with the trust I want to get into, and this was that we're going to try to get as much as we can. Some other things that we talked a little bit about is that if you have property in multiple states, because this is one of those areas, if you've got property in Florida and California and wherever, right, Oklahoma, whatever it might be, or here in Tennessee, you're going to be looking at multiple probates.
Yeah, if you have a will and you have property in different states, then you're going to have to file that will in those states as well as Tennessee in order to transfer that real property. And so that was one thing that the revocable living trust can help avoid, because if we can get it set up prior to death and have it funded with that property outside of Tennessee, then we don't have to worry about going through a probate out there as well as here.
And that's one of the things. Imagine now multiple probates. So that now the cost involved if you've got to go through probate in Florida, probate in California. Well, now Florida can be a little more expensive. California can be a whole bunch more expensive when it comes to probate. It's probably one of the more expensive states in the country, in fact. And then of course your property here. So now you got 3 states, 3 probates, 3 times the cost. In fact, and there may even be more of a multiple because of the costs in these other states and their process in terms of how long it might take and the rest of that.
And what some people don't realize is sometimes these costs can actually eclipse the value of the asset. When you're talking about timeshares, a lot of folks don't realize that they could carry or may need to go through probate depending on the type of timeshare, because some are contract, some are deed. So you want to be careful to make sure that you have all this in order, because if you don't, then I've had to explain to heirs, if you pay me to do this, it's going to be more than what this property is worth. Then what do you do?
Yep.
I mean, that's tough.
And I've run into the same thing with small stock accounts, different types of assets that someone didn't think to pass over into their trust, and now all of a sudden we've got a probate issue, or you know, and it's something that could have been avoided, and the probate costs more than what the asset. So it's kind of a waste. This is one of the areas too, conservatorship. Speaking of which, when you get into, we talked about what happens probate when someone dies. All right, the next part is living probate, or basically what is a living probate, and this has to do with someone that becomes incapacitated. So here again is some value to where a will has no value to you whatsoever. There, a power of attorney can sometimes help you avoid conservatorship, but not always. Okay, and it's amazing. Institutions can still choose whether to accept the power of attorney. Depending, if it's an older power of attorney, they may take issue with that. They may be concerned of liability. If this, in fact, is the correct document, are there other powers of attorney out there? And as such, they may require you go to the court to get a court order, basically a conservatorship, so that they can feel more comfortable and that they're not going to have a liability. This is one of the areas where trust can be a big benefit.
Yeah, it really can. And where we're seeing it help is, let's say your parents or parent is becoming incapacitated. You may start out signing off on checks using the power of attorney, and that's fine, but at some point you start having the control, a bulk of the assets, and the people that you're dealing with, the banks or the real estate agencies or whatever, are really starting to scrutinize these documents, and at that point it's really too late to go back and change things if you need to update them or get new language put into them, because the person you're helping is incapacitated and doesn't have legal capacity to sign new documents. So what I'm hearing over and over again is, if the client has a revocable living trust and you transfer the assets to the trust, and then you transition power over those assets from the parent who's incapacitated as trustee to the child as trustee, it's a much more seamless and accepted position for handling those assets than trying to do it through the power of attorney.
You know, I'll give you a kind of an analogy of that. If you think about a trust as a business in a sense, all right, if someone, if the head of that business, head of the company, the president of the company, let's say, if they became incapacitated, we have a hierarchy there. We've got someone else that's going to step into the place, maybe the vice president, whatever that is, right? They step in. They've got full signing power and everything as a corporate officer to be able to then continue the business of that business, all right? It's very similar with the trust. You're the person in charge of the trust during your lifetime, but if you became incapacitated, you've already named your successor. They're able to move into that position, have those same powers, be able to keep a seamless transition of being able to pay the bills, take care of whatever business needs to be taken care of. So again, this is where a trust can be so advantageous, more advantageous than a will. Now again, we're going to talk about asset protection. In particular, in the last few years there have been some changes in the laws that affect IRAs and retirement accounts, and this is an important factor when it comes to asset protection, because if you have an IRA, let's say, and that you've started for your retirement, you have certain protections under the law. And those protections under the law that you have are not, unfortunately, transferable. They could be to a spouse, in fact, let's talk about the difference there, Russ, because that's an interesting thing, too. A spouse has the ability to be able to take it as an inherited IRA, or they can do it what's known as a spousal rollover, basically a spousal IRA. Now it becomes theirs, and all the benefits, all the protections, everything that went with the original owner is transferred to the spouse.
Yeah.
Now, if the spouse does elect for inherited, and there are times when we can do a little bit of that, they lose that protection as far as that asset protection feature, and of course when it goes to the children, the same. But now let's talk about that, you know, what that can mean to them in terms of putting that asset at risk.
Yeah, the Supreme Court came out a few years ago and mentioned that, or basically held that if you inherit an IRA, it no longer has the same asset protection against your creditors that it would if you were the one setting up the IRA. And so what we've done is taken that problem and tried to solve it, or have solved it, through the use of trust. So instead of transferring an IRA to the person you want to receive it, and if they take it as an inherited IRA, it's exposed to their creditors, what we're instead doing is having the IRA pay to a trust that would then hold it for the benefit of that person. And as long as it's in the trust, then it's not subject to that person's creditor claims, as long as the trust is properly prepared. Okay. And you got that protection, and yet we can style the trust so that it still gives us the same stretch out provisions that you normally would have, using the beneficiary's life expectancy for determining the payout.
This is so important. This is one of those areas that, again, think what Russ just talking about, like the stretch out. So in other words, if you have your own IRA, at age 70 and a half, you have to start taking required minimum distributions. The IRS requires that. They want to start receiving their tax money, and that's the requirement. And it's spread out over your lifetime. It starts out with a factor of 27.4, so it's a little under 4% to start, and then gradually each year it goes up a little bit each time. Now, when you inherit an IRA, on the other hand, now it's not 70 and a half anymore. If it's an inherited IRA, and we're going to say non-spousal in this situation, same exception if a spouse elected to take an inherited, and I'm not going to get too far over there, but let's just say to the children, inherited IRA, at whatever age they are, the year after the year in which they inherit the IRA, they have to start taking required minimum distributions based on their age. All right, now this is where, if they're taking those, as they're taking those required minimum distributions and are taking that income, now that inherited IRA, though, is also subject to any other type of claims that someone might have against it. All right, so an example would be when Russ was talking about, and by the way, on the inherited IRA, this is one of the important things. If you leave it to them directly, they can still do this if it's done, if the beneficiary designations are set up correctly. They can stretch it out over their lifetime. Potentially, if they pass away and have not used up all the money, it could go the same way for the grandchildren in the same way. So you can stretch these out and take advantage of these tax deferral, or in a Roth situation, even tax-free benefits for potentially generations. Now, what's the problem that we can run into? If they receive it, it's their asset. If they got into any kind of trouble with bankruptcy, with divorce, IRS problems with taxes. Right? I got that money and I didn't pay tax on it. Those kind of things, they can come after that asset as well. However, if it's left to them in trust, now their other assets may be at risk. Their personal assets in any of these type situations, personal injury and lawsuits is another that come to mind. So their assets may be at risk, their personal assets, but the stuff you left to them in trust, including the IRAs, would not be subject to those creditors. In other words, it could be protected for them. All right, and as Russ said, as long as the language is done correctly, they can still take advantage of that stretch, and that's so important to give them the ability to control the tax, do their own tax planning basically, and how much they can take more if they want, or if it's prudent to do so. But they don't have to, and that's the difference. Without the proper language, they may be forced to cash that IRA out in like 5 years maximum. In other words, they would lose all those tax benefits of either tax deferral or, again, in a raw situation, tax-free benefits. All right, we're going to take a quick break. When we come back, we're going to get into this a little more. And again, on estate planning, the importance is not just that. First off, you got to have a plan, okay? So come on in and we'll get a plan together for you. The second part is understanding the importance of having your documents done correctly. This is not a do-it-yourself type project, okay? So we're going to get into this and more. Join us here. We'll be right back on the Retirement Report.